Hi everyone, Dave Sugden of Evidence at Trial. Let's talk about hearsay. Hypothetically, can evidence that a person simply took a certain medication ever be considered hearsay evidence? Our gut answer is probably a quick no. The person didn't declare anything. So are we even talking about a declarant, let alone an out-of-court statement? But if we consider this hypothetical a little more, it can really crystallize our understanding and application of the hearsay rule. So let's get into it. Let's suppose we have a case where it is alleged that medicine to treat headaches was causing heart attacks. The defense wants to introduce testimony that the person who invented the medicine had taken the medicine himself. The defense calls a colleague of the inventor who seeks to testify, "I saw the inventor take the medicine." The evidence is relevant because if the inventor is willing to take the medicine, such conduct implies that the medicine is safe. But could it be hearsay? We have a potential declarant, in other words, the inventor, engaging in out-of-court conduct, but not saying anything yet. But when it comes to hearsay, the definition of an out-of-court statement is more broadly defined to include a person's oral assertion, written assertion, or nonverbal conduct if the person intended it as an assertion. We see the key language is assertion. An assertion is something someone says or does in order to communicate, one, a fact, or two, an opinion that is intended to be accepted as true or accurate. In other words, when analyzing whether something is a statement, the focus is on the intended message. So going back to our hypothetical, on first glance, there does not seem to be any hearsay issue because there's not any verbal communication. But what if there was an out-of-court statement just before the inventor took the medicine? Suppose the witness wished to testify, "I heard the inventor say, 'I have a pounding headache,' and then I watched him take the medicine." We have a verbal assertion plus nonverbal conduct, the inventor asserting that he has a pounding headache and then taking the medicine. Is that hearsay? Whether something is hearsay turns on why a party is offering the statement into evidence. In this case, we're told that the plaintiff is alleging that the medicine causes heart attacks, and the defense wishes to introduce the fact that the inventor took the medicine to prove the medicine is in fact safe. Turning then to the statement, "I have a pounding headache," is the defendant offering the statement to prove the inventor had a pounding headache? Not at all. Whether the inventor did or did not have a headache has nothing to do with whether the medicine is safe. Put another way, the defense is not offering the statement to prove the truth of the matter. In other words, the existence of a headache. And then subsequently taking the medicine, if anything, asserts that the medication can help treat headaches. Thus, no hearsay. Now, suppose the witness instead wished to testify, "I asked the inventor whether the medicine was safe. The inventor said, 'You think this medicine is dangerous? Watch this.' And then he took the medicine." Hearsay? As an initial matter, we have several out-of-court statements to consider. As a general rule, most provisions of the federal rules require each assertion within a narrative to be considered. Exceptions to this assertion by assertion rule occur when the hearsay focuses on the nature of the speaker. For example, once a declarant is deemed a co-conspirator, the hearsay rule no longer applies. In this case, each communication must be considered both individually and as a collective whole. So first, we have the witness testifying, "I asked the inventor whether the medicine was safe." Although the witness is out on the stand, he or she is repeating a prior out-of-court verbal communication. However, the communication was a question, not an assertion, and therefore not a statement as defined by the hearsay rule. Second, the inventor then tells the witness, "You think this medicine is dangerous?" Again, we have an out-of-court sentence that is framed as a question. The inventor then says, "Watch this." Typically, when a person makes a command or gives a direction, the purpose is not to assert anything. Example, turn left at the light, pass the salt. These commands or directions are sometimes called non-assertive verbal conduct. The phrase "watch this" in isolation appears to simply be non-assertive verbal directions. But of course, human communication is complex. People can be intentionally sarcastic, saying one thing but meaning the exact opposite. In our current hypothetical, it is obvious that the inventor's intended communication, even though each individual component is a question, then a direction, and then nonverbal conduct, the intent is that the medicine is safe. When a declarant's words or conduct or a combination implies a fact, it's then deemed an assertion. In other words, it constitutes a statement. Thus, the words and conduct taken together constitute a statement and trigger the hearsay rule. So yes, someone taking medicine or engaging in nonverbal conduct can trigger the hearsay rule if the conduct is intended to be an assertion of some fact that the proponent is offering to prove. So here it is, hearsay, when we're talking about nonverbal conduct. Folks, I hope this was helpful. If it was, please like, subscribe, hit the notification button. If you want a topic covered, leave a comment. If you want to do a deep dive on these evidentiary issues, check out our online course page at evidenceattrial.com. Thanks for watching.